what we're going to talk about today is making your referral sources legal. And just by way of background, as probably most of you know, the baby boomers are retiring at a record level, and their life expectancies are greater than what we've seen in the past. So as a healthcare provider or supplier, why should you care? Why do you care if there's going to be more and more baby boomers retiring? Well, obviously because the demand for healthcare services is only going to increase. So you're going to have more boomers competing for limited healthcare services and limited dollars. And as a healthcare provider, you also want to be in that competitive pool for those dollars. I know that you, just like me, are entrepreneurs. You want to get your next patient or your next client in the door, but there are certain ways to do it legally and ways that are not so legal or, frankly, are illegal. The healthcare industry, whether we like it or not, is based on referrals and marketing. That's just the way the American system is set up. And so you can't wait for your next client or patient to walk through the door. You have to figure out, just like every other entrepreneur in this country, how you're going to get your next patient or customer. So why can't you market your healthcare business any way you want? Well, like any industry, and particularly in the healthcare industry, there are rules and regulations which kind of put guardrails around what you can and what you can't do. And I've told many of my clients, you are involved in one of the most highly regulated industries in this country. And so, and because that there are limited dollars out there potentially for you to be paid for your services, you have to follow these guidelines. And it's not the patients or your clients who are setting up these guidelines. It's the people who pay you for the services. And when I talk about payers, I'm talking about the federal government, particularly Medicare. I'm talking about the state governments, particularly Medicaid, or a private insurer. They are the ones who are paying for your services, as you know. So what the government doesn't want, and private payers don't want to see, is you providing incentives for patients to use your services. And the reason is because there may be a tendency for the patient or your customers and for you to provide services that may not be necessary. Now, I'm not saying that as a healthcare provider or supplier you are doing that, but I'm just telling you that is what the concern is from the payer's perspective, that if you offer incentives to marketing companies or patients to use your services, there could be the tendency to overutilize those services. Like I say, this does not mean you can't market your services to patients or customers, but it does mean that there are certain laws or contractual terms that are going to restrain the manner in which you market your healthcare services. So what are those laws that we talk about and we deal with every day? They impact your referral sources, and your referral sources can be anywhere from long-term care facilities, home health agencies, pharmacies, physicians, and hospitals, or they could be your own employees if you're paying them to generate business for you, or they could be independent contractor salespeople. And with those in mind, there are certain laws, particularly on the federal level, that we deal with. And what we want to avoid is what we call the F word. And the F word in our context is fraud. So if you're marketing your healthcare services or somebody else is marketing your healthcare services on your behalf, you have to be aware of the federal and state anti-fraud laws. And I'm going to go over a couple of the big ones now, but believe me, there are a number of them out there that we're not going to discuss today but these are the ones that you have to be familiar with. The first one is what's known as the AKS, or the Federal Anti-Kickback Statute. This is the big one. This is the one that providers and government and federal government and state officials routinely tout when they go out and enforce regulatory issues. And it's a felony statute, unfortunately. It applies to healthcare providers. Now, it is a intent-based statute. So to violate the statute, you have to knowingly and willfully do what the statute prevents. And what does it prevent? Well, you can't offer or pay, and that's critical there. It doesn't only apply to you paying to get referrals. It also applies to offering to pay. And what do you have to offer or pay in order to violate the statute? The term that's used in the anti-kickback statute is remuneration. And remuneration basically means anything of value. And it doesn't have to just be cash. It could be a benefit. It could be a gift card, anything that would benefit the person to whom you are giving or offering to pay for the referral or for their services. It applies to furnishing or arranging for the furnishing of payment to be made under a federal health care program. Now, federal health care program, most people think of Medicare, but there are a number of federal health care programs that fall within the ambit of that definition. And Medicare obviously is the big one, but it's also Medicaid. And it also could include other programs that involve federal dollars. So that's the federal anti-kickback statute. The other big one that we talk about is the beneficiary inducement statute. This one is very similar to the anti-kickback statute, but this is a little bit different in that it prohibits a healthcare provider from offering or giving anything of value to a Medicare beneficiary that you know or should know is likely to persuade that person to purchase an item that is payable by a federal health care program. So again, a little bit different from the anti-kickback statute. The beneficiary inducement statute targets providers who are offering benefits or incentives to Medicare or Medicaid beneficiaries. So again, we have that term, anything of value, remuneration. So if you're going to provide incentives for your customers to come into your door or your patients that are covered by a Medicare or Medicaid program, you need to make sure you don't violate the beneficiary inducement statute. Now, the beneficiary inducement statute does have a caveat or a carve out in that it does not prohibit giving incentives that are of nominal value. And the government has defined nominal value to mean no more than $15 per item or $75 in the aggregate to any one beneficiary on an annual basis. So if you're going to give out anything of value to a Medicare or Medicaid beneficiary, you need to keep track of who you're giving it to and the value of that item, whether it could be a gift card or anything that the beneficiary could use in order that you use to attract to bring them into your office. The last one I'm going to talk about is probably the most complicated, and that is the federal Stark Law. The federal Stark Law only applies if a couple of entities or persons are involved. A physician has to be involved in the transaction. The physician has to have some type of financial relationship, and financial relationships could be an ownership interest or a payment relationship. So if the physician is getting something of value through a payment or has an ownership interest in your entity, then the Stark Law could possibly be implicated. The Stark Law only applies to certain, what the federal government has called designated health services. So the Stark Law does not apply to every kind of service that you could possibly provide. And I've listed on this slide the designated health services. Now, the ones that I see that implicate the federal Stark Law the most are clinical lab services, physical therapy services, occupational therapy services, outpatient speech language pathology services. Skip down a little bit, we go to DME and supplies, and then home health services. So if you're in an industry that is providing any of those types of services, you have to be aware of the federal Stark Law if there is a physician involved in referring business to you and there's a payment going to that physician, or there's some kind of ownership relationship. The federal Stark Law is much more complicated than what I've presented on these one or two slides, but just know that if you have a doctor or physician involved, there's a financial relationship, and it involves one of these designated health services, you need to analyze that relationship under the Stark Law. There are exceptions to the Stark Law, as there are exceptions to the anti-kickback statute, which we're going to get into. One of the exceptions to the Stark Law that we see and that I see used a lot is a healthcare provider can provide non-cash items to a physician if the amount of those, the dollar amount of those non-cash items don't exceed $416, and that's for fiscal year 2019. So, like I said, both the anti-kickback statute and the Stark Law have exceptions. Now, the anti-kickback statute exceptions are called safe harbors. So if you hear the term safe harbor with respect to the anti-kickback statute, what that means is that in order to avoid or try to avoid prosecution or getting into trouble in violating the federal anti-kickback statute, you want to have your SHIP, meaning your entity, your healthcare providing entity or supplying entity, go into a safe harbor, meaning that you're kind of, instead of floating out on the sea of potential enforcement action by the federal or state government for violating the anti-kickback statute, you are going to steer your ship into a safe harbor, meaning you're going to try to comply with some of the exceptions of the anti-kickback statute. So basically, a safe harbor is a hypothetical fact situation such that if the arrangement falls within it, then the anti-kickback statute is not violated. And we're going to talk about some of the more important ones, or the ones that I see the most in counseling clients. So I just want to make sure everybody understands, if the arrangement doesn't fall within a safe harbor, that does not mean necessarily that the arrangement violates the anti-kickback statute. Rather, if it falls within a safe harbor, we try to analyze that agreement to make sure that under the language of the anti-kickback statute itself, the applicable case law, and other published guidance, that we can fit the fact situation into one of those safe harbors. So there are 5 safe harbors that are particularly relevant to providers and suppliers. The first one that we're going to talk about is the safe harbor for small investment interest. So if there's an investment going to be made in a small entity, the safe harbor says that remuneration, which again means giving something of value, does not include a return on the investment if a number of standards are met. And one of the more important standards of this small investment safe harbor is that no more than 40% of the investment can be owned by persons who can generate business for or transact business with the entity, and no more than 40% of the gross revenue may come from business generated by investors. So if you have investors who want to invest in your small business entity, healthcare provider, and they are referral sources, you may want to try to fit their ownership interest into the small investment safe harbor. The next one I want to talk about is the safe harbor for space rental. Say you're a healthcare provider and you want to rent space within a space that is next to or within a lease agreement with a referral source. There is a safe harbor to the anti-kickback statute, which provides that giving something of value doesn't include a lessee's payment to a lessor as long as the 5 standards are met, which I've listed here. Now, the most important one is, in my view, is the 5th one. The aggregate rental charge must be set in advance. So if there's going to be a lease agreement, the rental charge, has to be set in advance. It has to be consistent with fair market value, and it cannot take into account business generated between the lessor and the lessee. That's what if there's going to be an enforcement action, if you're renting space from a referral source, that's going to be the most important one that the enforcement agencies are going to look at. They will look at the other ones, but primarily they're going to look at that 5th one. Now, there is also a safe harbor for equipment rental, which basically is the same as the safe harbor for space rental. And again, the most important one is the aggregate rental value charge must be set in advance, be consistent with fair market value, and not take into account business generated between the lessor and the lessee. Another one that we see, and this is the one that I use and most healthcare attorneys use most often in making sure your referral sources fit within one of the safe harbors of the anti-kickback statute, is the personal services and management contract safe harbor. So remuneration does not include any payment made to an independent contractor if, and you have to meet all of these standards, these 5 standards, these 8 standards, but the most important one is the compensation must be set in advance, be consistent with fair market value, and must not take into account any business generated between the parties. So again, if you are hiring an independent contractor to do marketing for you, basically what this anti-kickback statute safe harbor says is that you cannot pay that independent contractor based on the amount of business that they generate for you. You cannot pay them on a commission basis. Rather, that compensation in the agreement has to be set in advance. It has to be consistent with fair market value and cannot take into account any business generated between the parties. So if you're thinking about entering into an agreement to pay an independent contractor on the amount of business that the independent contractor generates for you, you can't pay them based on a floating commission basis. And that's one that really trips up a lot of healthcare providers when they want to hire an independent contractor to do marketing for them. Now, there is a difference between the safe harbor I just talked about, and which dealt with independent contractors, and the safe harbor for employees. So if you have employees of your healthcare entity that you want to do marketing for them, there is a safe harbor that actually addresses your employees. So there are a couple of requirements here. first of all, there has to be an employer and employee relationship. The employee, by definition, cannot be an independent contractor. That employee has to be a bona fide employee. You have to be a bona fide employer for this safe harbor to be invoked. And that employee can do marketing for you, and you can pay that employee to do marketing for you and pay that employee on a commission basis. There are some courts, federal courts, who have looked at this safe harbor for employees and have questioned this phrase, for employment in the furnishing of any item or service for which payment may be made in whole or in part under Medicare. What the federal courts really kind of look at when they look at this safe harbor and you're trying to fit your situation into the safe harbor is that some federal courts are saying you can't just pay your employees to go out and do marketing for you and pay them on a commission basis. They have to be doing something further, and that further is in the definition of this safe harbor. They have to be assisting you in furnishing items or services for which payment may be made under Medicare or Medicaid. So they have to be doing something, either reaching out to potential referral sources, doing education to those providers, helping you inside the office, fill orders. So they just can't be out there doing marketing and getting paid a commission for that. So even though many providers think, well, I've got an employee, the safe harbor says I can pay them a commission to go out and do marketing, you have to be cognizant of the federal courts who have strictly interpreted this statute. So we've talked a lot about Medicare and how the federal government uses these statutes to enforce prohibitions and setting up guidelines for Medicare. But the federal government is not the only player out there. The states are also involved because, as you know, the Medicaid is a federal and state partnership where states get get federal government dollars for their Medicaid program through their FMAP. So all states have statutes prohibiting kickbacks, fee splitting, patient brokering, or self-referrals. Some states, but not all states, have anti-fraud statutes that only apply when the payer is a government health care program. So some states will have anti-kickback statutes that only apply to their Medicaid program. Other states have anti-kickback or anti-fraud statutes that apply. It doesn't matter who the payer is, whether it's Medicare, Medicaid, or a commercial private insurance company. So when you're analyzing your fact situation under the anti-kickback statute, you have to be cognizant of the fact that the state in which you are doing business, it's not only the state in which you are you're registered or incorporated, but any state in which you're doing business, you have to look at that state's program and rules and regulations to determine if there are also any federal or state guidelines and requirements. Now, we talked a little bit about the employee versus the independent contractor when we talked about the anti-kickback statute. And I want to go into that difference a little bit more in detail. The federal government has repeatedly voiced concern about percentage-based compensation arrangements involving 1099 independent contractor sales agents. And what does that mean? That means, again, if you are thinking about hiring a marketing company or a person and not employing them, but using them as a 1099 independent contractor, the federal government has put out opinions it's saying basically that you cannot pay that independent contractor based on commission. There is a advisory opinion that the federal OIG put out, number 06-02, which says that percentage compensation arrangements, because they relate to the volume or value of business generated between the parties, are inherently problematic under the federal anti-kickback statute. So I'm not going to go into this in great detail, but again, if you want to hire an independent contractor to do your marketing for them, what I'm basically telling you is you cannot pay them on a commission basis based on the amount of business they generate for you. I speak about or write about in the slide a case in 1996 that came out of Florida, in which the Florida Appeals Court said that the agreement between a DME supplier and a marketing company was illegal and unenforceable because the marketer's receipt of a percentage of the sales it generated for the DME supplier violated the federal anti-kickback statute. So in a number of years, but more recently, there have been a number of enforcement actions involving commission payments to independent contractors. If you're going to pay an independent contractor, again, make sure it complies with the federal anti-kickback statute. Now, what a lot of my clients ask me is that, well, what if I don't want to take Medicare or Medicaid patients and I just want to pay an independent contractor for marketing my business, and I want to pay that independent contractor on a commission basis? Well, again, the OIG has spoken on this scenario and said that even if the arrangement will only focus on commercial payments and there's a carve out for Medicare or Medicaid, there still may be a violation of the anti-kickback statute, particularly if you have another arrangement with that marketing company that deals with Medicare and Medicaid payments and their marketing for those particular programs. I won't get into that in great detail, but again, if you think you're just going to carve out Medicare and Medicaid from your healthcare business and hire an independent contractor to do marketing, make sure that you don't run afoul of the OIG and its advisory opinions. So, having said all that, what happens if you want to use a marketing company? If you want to use a marketing company that generates patients, and I use a DME supplier as an example, but this could pertain to any type of supplier or provider that receives Medicare or Medicaid reimbursement. Again, I want to stress that don't pay commissions to the marketing company for generating that business to you, unless it complies. Make sure your business complies with the personal services and management contract safe harbor. And again, that doesn't mean that you can pay commission. It means that you have to pay that marketing entity based on the within the guidelines of that safe harbor. Now, I want to talk briefly about why you may be asking yourself why the federal government cares that you want to pay commissions to an independent contractor, whereas you can pay commissions to an employee. And the bottom line is, as I state on slide 34, it's control. The federal government believes, and most state governments believe, that if an employee is doing marketing for you, you have more control over that employee than you do an independent contractor. And that's the bottom line. The independent contractors are less accountable to you as a healthcare provider in marketing your services. You don't know what the independent contractor is saying about to your potential referral sources about you, about reimbursement, about Medicare and Medicaid. And the government draws the line where it says if you're an employee, your employer has a little bit more control. They can do training for you. They can go out and watch how you perform your services, and it's a little bit better off from the government's perspective that you have that ability to rein in your employees where you may not have that opportunity to rein in your marketing agents who are independent contractors. A lot of commentators have and continue to suggest that the federal government broadened the employee safe harbor to independent contractors based on a commission basis. And the bottom line is the federal government has said we have declined to adopt this approach because we're aware of many examples of abusive practices by sales personnel who are paid as independent contractors and who are not under appropriate supervision. Okay. Further, if the individuals and entities desire to pay a salesperson on the basis of the amount of business they generate to be exempt from civil or criminal prosecution, they should make these salespeople employees where they can and should exert appropriate supervision for the individual's acts. So it's not just me saying this, it's the federal government pronouncing these guidelines with respect to independent contractor marketing agreements. So let me switch subjects a little bit here and talk about loan closet agreements, in particular how they apply to DME suppliers. Now, a loan closeting agreement basically means that a DME supplier can place inventory or a hospital in a physician's office. But the loan closet agreement has to be for the convenience only of the hospital's or physician's patients. And the hospital or the physician cannot financially benefit from the inventory. Another guideline or standard is if the DME supplier pays rent for a space in which the consigned inventory is placed, the arrangement has to comply with the space rental safe harbor that we talked about previously. Let me switch gears a little bit now and talk about preferred provider agreement. What is a preferred provider agreement? Again, I use DME suppliers as an example. A DME supplier can enter into an agreement with a hospital subject to patient choice. You can't dictate this to the patient. It's up to the patient to choose. The hospital will recommend the DME supplier to its patients who are about to be discharged. The DME supplier can enter into a similar preferred provider agreement with a physician, a home health agency, a long-term care facility, or a wound care center. Those are just some examples that you can possibly get your foot into the door in a hospital and have that hospital kind of direct patients towards you if you comply with these standards. Now let's talk about medical director agreements. I know a lot of entities, healthcare entities, have medical directors that they use to provide them guidance, to look over records, to make sure that from a physician's point of view, they are operating their healthcare entity within certain legal and medical standards. And for medical director agreements, again, I use DME suppliers, but it could be a pharmacy, it could be any other type of healthcare provider if you want to enter into a medical director agreement. You can enter into an independent contractor agreement with a physician, but the medical director agreement must comply with the personal services and management contract safe harbor to the anti-kickback statute, which we talked about already, and the personal services exception to the Stark law. Now, because there is a physician involved and there's probably going to be payment made to this physician, both the anti-kickback statute and the Stark law are going to be implicated. Some more of the requirements for the medical director agreement is that the physician must provide substantive services. So you can't just have a physician friend and tell the physician friend, hey, it'd be great if we can enter in an agreement. You don't have to do anything, but I'll pay you some money for referrals if you refer patients over to me. That's a no-no. The physician has to be providing substantive services to your entity. And the compensation that you can pay to the physician must be fixed 1 year in advance and be fair market value equivalent of the physician's services. So those are the important highlights of what you need to do in order to meet the requirements of the medical director agreement. What if you want to rent space from a physician or other type of referral source? There are also guidelines for this. A supplier can rent space to or from a physician so long as the rental agreement complies with the space rental safe harbor to the anti-kickback statute, which we talked about, and the space rental exception to the Stark law. Now, again, because if you're renting space from a physician, there is a physician involved in a financial relationship with you, the Stark law is going to be implicated. You can also rent space from a non-physician referral source if the two bulletins that I have up on the screen are complied with. One is the rental agreement must be in writing and have a term of at least 1 year, and the rent must be fixed 1 year in advance and be fair market value. Now, the last topic I want to talk about is something that is fairly new, and that is with respect to clinical laboratories and ACCRA. You've probably heard of ACCRA, but I'm going to give you the long and short of this as quickly as I can. ACCRA, which stands for Eliminating Kickbacks in Recovery Act of 2018, was designed and passed with the intent to prohibit individuals from referring substance abuse patients in exchange for kickbacks to recovery homes, clinical treatment facilities, and laboratories. Now, I'm going to focus on laboratories because I've had a number of laboratory clients come to me and ask me how ACCRA is going to affect them with respect to how they market their services. And what I want to say generally is that most commentators and healthcare attorneys agree that ACCRA appears to exceed its underlying legislative intent. I won't go into deep detail about the legislative intent of ACCRA, but the way the law was drafted seems to go beyond what the originators had in mind when they drafted it. So what is ACCRA? ACCRA prohibits knowingly and willfully, so it's intent-based. You have to knowingly and willfully violate it in order to be prosecuted. So you can't solicit, receive, offer, or pay anything of value to a recovery home, clinical treatment facility, or laboratory with respect to services covered by a health benefit program. Now, the term health care benefit program includes any public or private plan or contract affecting commerce. So it's very broad in what it prohibits. Like I said, I'm going to focus on the term laboratory, and ACCRA defines a laboratory to include all clinical laboratories. So thus, what I mean is all referrals for clinical laboratory tests implicate ACCRA regardless of whether the tests relate to substance abuse testing or treatment. Some of the deficiencies of ACCRA, ACCRA does not define the term referral. Basically, based on what ACCRA does define, ACCRA is a new public and private payer intent-based criminal anti-kickback law that prohibits any form of remuneration in exchange for referrals to or an individual's use of entities that meet the definition of recovery homes, clinical treatment facilities, and laboratories. And the referrals to laboratories include referrals to laboratories unrelated to substance abuse testing or treatment. So that's where the kick is in ACCRA. Typically, we found in the anti-kickback statute that it was narrower than ACCRA. Now, ACCRA has expanded referrals to laboratories to include substance abuse testing and treatment and any other types of referrals to laboratories. There are 8 exceptions to ACCRA. I'm not going to go in detail into those, but as this slide shows, there are anti-kickback exceptions and safe harbors that are inconsistent with ACCRA, and vice versa. ACCRA is inconsistent with some of the corresponding anti-kickback exceptions and safe harbors. In addition, not only does ACCRA apply, you also, again, have to look at state laws applicable to kickbacks, fee splitting, and self-referrals to make sure that your referrals to your clinical laboratories are not inconsistent with ACCRA. So I'm not going to go into detail on this slide about what ACCRA prohibits, but basically what ACCRA is saying is that you cannot pay not only independent contractors, but the big impact is that you can't pay your employees to do marketing to bring referrals in to do your business. And that is a huge loss for clinical laboratories. There are certain exceptions to ACCRA that we could possibly use as workarounds if you want to pay your employees to do some marketing for you that don't involve paying them commissions. I have counseled clients on that, a couple of workarounds that I'm not going to go into detail here. But mind you, there are, ACCRA is new. To my knowledge, there hasn't been any enforcement actions brought against clinical laboratories yet. But obviously you don't want to be the first ones to be the target of those enforcement actions. So I counsel you to speak with your healthcare attorney or your compliance director if you're involved in a clinical laboratory and you're marketing your clinical laboratory to referral sources. Right now, there are no other regulations out there regarding ACCRA to define it, to put guardrails around it, to help the healthcare industry manage its prohibitions. So again, it's new. It was well intended, but it was poorly drafted, and it's up to us as attorneys, as compliance officers, and healthcare providers to kind of manage through it. Now, having said that, I want to thank you for your time in giving me your time in allowing me to give my presentation today. I hope you learned something of value. If you have any questions, again, feel free to contact me or your healthcare attorney or your compliance officer.